think I understand. And if I have any more, I'll just come to
Please,
you.
and we have this amazing prosecutor here today that can answer this stuff better than I can.
Mr. Money?
Thank you, Ms. Johnson. Thank you for working on this important issue. I think over the last 15 or 20 years, this is one of the scariest scenarios that I read about in the news. Thankfully, I'm not in criminal law, so I don't have to prosecute or defend cases like this. But there's horrific stories on both sides. And so I'll use Representative Little's word, temerity. I'll step into this not only because of my lack of legal experience, but just the sensitivity of the topic. And my concern here is I've got layers of concerns on both sides because I want to solve the problem that you're solving, and I don't know where I am exactly on this bill yet, but ultimately a judge or jury is going to have to prove beyond a reasonable doubt these things. And so you back up and you already have a situation in which if a crime occurred, it occurred in an intimate setting where usually there are no other witnesses or any evidence other than the defendant and the victim explaining what they think happened. You have usually in both cases alcohol. I appreciate what you said about voluntary intoxication. That's true, and I would encourage everyone to not go to the frat party and get drunk and look to carry some, to go home with someone. But in that case, you have alcohol. You have consent, which in intimate settings, whether there's alcohol involved or not, is sometimes murky, and it can be given and withdrawn at various times. And then you have a knows or reasonably should have known standard that it complicates it even more. And so all of that being said, I do not want any young woman to ever, or old woman or person, to be taken advantage of, whether they have had a drink of their own volition, have been slipped something by someone else. I mean, people should be protected from sexual violation in every respect. I also don't want someone to be accused and convicted of something that is
I get it.
difficult and
I get it.
murky.
Yep.
And so I want to know, and I know this may be for the prosecutor that's going to come up and talk, like in real life, in real situations, how do we know that this gets us somewhere where we have him saying, I didn't know that she withdrew her consent, and she says, well, you reasonably should have known that I withdrew my consent. And he says, that's not the way I remember it. I mean, does this really even get us closer to anything that we can prosecute beyond a reasonable doubt?
I do, and I'm going to have the prosecutor speak to some of those examples. When you ask me this question, I feel the same pull that I felt with Representative Little, that I don't want a pendulum to swing so far the other way that, well, let's just look at the power dynamic here. We are typically talking about women as victims, male as offenders, but that's not always the case, right? And I don't want that to be where, we all think about college and the rite of passage of the drunken parties and everything else, but we can't make the rite of passage also rape.
Right.
And so part of the challenge here, when you said intimate settings, also people hold people up in an alley where there's no witness. And that's part of it. These are not always intimate settings. Sometimes these are settings that the perpetrator puts in place that there is no witness, there's no ability to have a witness, and you are taking their word versus the other. Or we are seeing the manner in which people are being incapacitated. I will tell you one other story. When I was a prosecutor,